Criminal law. Voluntary manslaughter. Loss of control. The loss of control defense was introduced by Section 54 of the Coroners and Justice Act 2009 and came into force in October 2010. Killings committed prior to this date continue to be governed by the common law defense of provocation. The defense of loss of control is a partial defense that may reduce liability from murder to manslaughter. It does not operate to absolve the defendant of liability completely. It is not a general defense and exists only for the offense of murder. Section 54 of the Coroners and Justice Act 2009 provides, a person who kills or was party to a killing may be convicted of manslaughter rather than murder where there exists a loss of self-control, b. the loss of self-control had a qualifying trigger, and c. a person of the defendant's sex and age, with a normal degree of tolerance and self-restraint and in the circumstances of the defendant, might have reacted in the same or in a similar way. In terms of the burden of proof, Section 54(5) provides if sufficient evidence is adduced, the jury must assume that the defense is satisfied unless the prosecution proves beyond reasonable doubt that it is not. In R. v. Remonsky, Bartish, 2017, Baroness Hallett VP, emphasized that the three components of loss of control are distinct and require separate consideration. What can be taken into account under one may be excluded from consideration under another. The three components consist of 1. A loss of control, 2. A qualifying trigger, and 3. The objective test. 1. Loss of control. Section 54(2) provides that there is no requirement that the loss of self-control be sudden. This represents a change from the law of provocation, which required the loss of control to be sudden and temporary as established in R. v. Duffy. This was a significant barrier to victims of domestic violence as demonstrated in R. v. Ahluwalia and R. v. Thornton, where the defendants waited for their abusive husbands to go to sleep before killing them. By virtue of Section 54(4), if the defendant acted in a considered desire for revenge, they cannot rely on the defense. This upholds the principle from R. v. Ibrams and Gregory, where the defendants lured the victim into the bedroom in revenge for how he had treated the defendant's girlfriend. 2. Qualifying trigger. The qualifying triggers are set out in Section 55 of the Coroners and Justice Act 2009. A qualifying trigger may only relate to either the defendant's fear of serious violence from the victim against the defendant or another identified person under Section 55(3), or, under Section 55(4), where the defendant's loss of self-control was attributable to a thing or things done or said, or both, which, a. constituted circumstances of an extremely grave character, and, b. caused the defendant to have a justifiable sense of being seriously wronged. According to R. v. Hatter, the question of what constitutes circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being seriously wronged is decided objectively. The case of R. v. Hatter also established that the breakdown of a relationship will not normally be regarded as circumstances of an extremely grave character, nor entitle the aggrieved party to have a justifiable sense of being seriously wronged. The issue of justifiable sense of being wronged was considered in R. v. Boyer, where it was held that the defendant could not have a justifiable sense of being seriously wronged, as he was committing a crime of burglary at the time of the killing. Section 55(6) of the Coroners and Justice Act 2009 provides two further limits as to what may be classed as a qualifying trigger. Under Section 55(6)(a), the fact that a thing done or said constituted sexual infidelity is to be disregarded. Under Section 55(6)(b), a person may not raise a qualifying trigger if they incited the thing done or said or the violence. Section 55(6)(a) was considered in R. v. Clinton, where it was held that sexual infidelity should not be used to deny the defense if there exist other qualifying triggers. The limitation based on incitement seemed to represent a move away from the law of provocation, where self-induced provocation could be relied upon as established in R. v. Johnson. However, in the case of R.V. Dawes, the Lord Chief Justice, Lord Thomas, stated that Section 55(6)(b) diminished but did not extinguish the position established in R.V. Johnson. His Lordship stated the revised position, as a matter of statutory construction, the mere fact that in some general way the defendant was behaving badly and looking for and provoking trouble does not of itself lead to the disapplication of the qualifying triggers, unless his actions were intended to provide him with the excuse or opportunity to use violence. 3. The objective test. Section 54(1)(c) requires that a person of the defendant's sex and age, with a normal degree of tolerance and self-restraint and in the circumstances of the defendant, might have reacted in the same or similar way. This is a question for the jury to decide. According to R.V. Clinton, sexual infidelity may be considered when looking at the circumstances under Section 54(1)(c). Under Section 54(3), circumstances which relate to the defendant's general capacity to exercise tolerance and self-restraint are to be disregarded. This excludes mental characteristics such as depression and post-traumatic stress disorder from being taken into account as seen in R.V. McGrory and R.V. Remonsky respectively. Similarly, in R.V. Meenzer, the appellant suffered from paranoid schizophrenia and antisocial personality disorder. He hit a care worker over the head with a fire extinguisher, killing her. The Court of Appeal denied the defense of loss of control on 2 grounds. First, the appellant could have no justifiable sense of being seriously wronged. Second, the appellant's paranoid schizophrenia and antisocial personality disorder were excluded from account in considering his circumstances under Section 54(1)(c). Furthermore, where the defendant is intoxicated, this will affect their ability to exercise self-control and must therefore be disregarded. The fact that they are voluntarily intoxicated will not prevent them being able to raise the defense. The approach was outlined in R.V. Asmalash, Dawit. The jury are to be directed to consider if a sober person in the defendant's circumstances, with normal levels of tolerance and self-restraint, might have behaved in the same way as the defendant. Different considerations would arise if a defendant had a severe problem with alcohol or drugs and was mercilessly taunted about the condition, to the extent that it constituted a qualifying trigger. The alcohol or drug problem would then form part of the circumstances for consideration. In summary, loss of control is a partial defense to murder, reducing liability to voluntary manslaughter. To raise the defense, the defendant must establish that at the time of the killing there was a loss of control due to a qualifying trigger and that a person of the defendant's sex and age, with a normal degree of tolerance and self-restraint and in the circumstances of the defendant, might have reacted in the same or similar way. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.